Welcome to the Robert H. Jackson Center in Jamestown, New York. I'm John Barrett, a professor of law at St. John's University in New York City, and I'm pleased to be here with three former Nuremberg prosecutors who participated in the work with Justice Robert H. Jackson at Nuremberg, Germany, prosecuting the senior Nazi officials during 1945-1946 before the International Military Tribunal. Let's set the stage for your work at Nuremberg by meeting each of you. Our guests, Whitney Harris, Bernard Meltzer, and Henry King, each was a lawyer and practicing. But let's get a little bit more specific. Whitney, where were you and what was your career before Nuremberg?
Well, I had started practicing law in a small law firm in Los Angeles. I practiced law for about 5 years. My senior law partner was very hard of hearing. On December 7th, I remember at about 10:30 o'clock in the morning, he called me on the phone. He said, "Whitney," he said, "the Japs have just bombed Pearl Harbor." Wow, I said, "Well, thank you, Mr. Goodspeed," and hung up the phone. I didn't believe this, but then I thought a little bit more about it, and I said, "My goodness, suppose that happened." So I turned on the radio. No television in those days, you know.
Right.
Turned on the radio. Sure enough, the Japs had bombed Pearl Harbor. The next day, I was applied for a commission in the United States Navy. Luckily got it. And so I served in the Navy throughout the war, but toward the end of the war, I was assigned by the Navy to OSS, which is the Office of Strategic Services. That was the forerunner of the CIA, you know, the spy organization. And I received training there in all kinds of weaponry and that type of thing, and I was very nervous about what assignment I'd get afterwards, but anyway, the OSS sent me to Europe to investigate war crimes on behalf of OSS. And I was in Nuremberg, I was in London when Justice Jackson came over with his nuclear staff, and I got acquainted with those individuals because I used to take documents to them occasionally when I found them that were very good and very incriminating. And eventually I was invited to join the staff and went down to Nuremberg in August 1945.
That's great. Bernie Meltzer, how about you? What were you doing before the road led you to Nuremberg?
Well, after law school, I went down to Washington and worked for the Securities and Exchange Commission. I had a wonderful boss, Jerome Frank, well known as a legal realist, and a very imaginative, warm person. And then after a couple of years doing that, I went back to Chicago, my home then, practiced law for a short time. The National Defense Commission was established, and I was asked to come back by one of the SEC commissioners who had become a National Defense Commissioner. That was Leon Henderson, and I went back, and after reorganizations, I found myself working for Dean Acheson at the State Department, and I was there on Pearl Harbor Day, and I didn't have a partner to tell me about it, and I didn't learn about it until 4 o'clock that afternoon when I went to a party, Office of Production Management, and they said, "Oh, here comes the State Department. He'll let us know." And I said, "Let you know what?" And I said, left immediately, and I remember my greeting from Dean Acheson. It was, "Where the hell have you been?" And we went to work, getting out dispatches and so on. And as for where I was, since Whitney has told you about his getting into the Navy, perhaps I should tell you how I did that. The day after Pearl Harbor, I turned up at a recruiting station, and I found I was practically blind, and they'd recruited a psychiatrist to help with the examinations, and when I finished, he said, "Young man, do you know where I'd like you to be in this war?" And I said, "No, sir." He said, "I'd like you to be a gunner in a Japanese And so time passed, and they wouldn't take me as an apprentice seaman, so an OSS chap said, well, I'll get you a waiver. So I became an ensign. Went off to indoctrination school, and right before I was invited to be to go to Nuremberg, I was in San Francisco. And they got how did I get to Nuremberg? Well, it was the Old Boys Network. Frank Shea, who had been Jackson's assistant attorney general when Mr. Jackson had been attorney general, called me up and said, did I want to go to Nuremberg? I had met him casually, and he knew a lot of people that I knew in Washington. And I thought about Nuremberg, and I didn't know very much about it, but it seemed that General MacArthur was not very anxious to have more naval intelligence chaps in his theater, so that was scratched. So I said, sure, and that's how I got to Nuremberg.
Okay. Henry King, how about you? Let's situate you before Nuremberg.
Absolutely. I was 4F because I was rejected for military service because of a heart murmur. And I rocketed through the Yale Law School, did reasonably well, and landed up at the Milbank Tweed firm in New York. And my wife was working on a secret project at Columbia University, and I was working hard there at Milbank, and we arranged to have Wednesday night dinners at Schraff's on Fifth Avenue. And one Wednesday night, I asked my wife, well, what do you do all day? I can't tell you. Well, it later developed she was working on the atomic bomb project. She said, by the way, what do you do all day? Well, I said, I read agreements, I modify them, and I change them. My God, she said, there's a world out there. We ought to be part of it. That made me restless at the Milbank firm. And as a result, I decided instead of a small fish in a big pond, I was going to be a big fish in a little pond. I invited a classmate of mine from Yale Law School out for dinner to crow about it. Frequently, the telling is more important than the doing. And I anticipated some non-taxable psychic income when I told my classmate, Ted Fenstermacher, that I was going to be a big shot in a small puddle. After the dinner, he said, well, Henry, he said, I don't want to upstage you, but I'm joining the U.S. prosecution staff at Nuremberg. Well, I didn't get to bed that night. I was on the steps of the Pentagon the following day, and it wasn't long thereafter, needled by my wife, that I was on a ship sailing to Nuremberg. So I attribute my going to Nuremberg to that connection, Yale Law School, with Ted Fenstermacher, who is not here today.
Now, let's begin to understand the focus of our conversation, Robert H. Jackson. Who was he in your awareness before you got to see him in action in Nuremberg? He obviously had a distinguished career rising through the Roosevelt administration to be Attorney General, and then was on the Supreme Court as of 1941, as each of you is a young lawyer. What was Jackson on your radar screen, Whitney?
Well, Jackson was really not known to be except. He was a member of the Supreme Court of the United States when I was admitted to practice before the Supreme Court, and I have the photograph in my studio, of course, of the Supreme Court with Justice Jackson. That was my vivid memory of Justice Jackson.
So you had an admission ceremony with him on the bench.
Correct, and so that was a memory that I retained at that time. Otherwise, I really didn't know anything about it. I was a country boy. I didn't know anything about these gentlemen from the big cities. They know all about that. Well, I mean, from the east, from the west.
Now, Bernie, you mentioned Jackson's work on the exchange of bases for destroyers. Explain what that deal was.
Well, the problem was that the British could use, obviously, destroyers in August of 1940, which was a very dark period in the war, so far as the British and their sympathizers were concerned. The technical difficulty was that although we had some mothballed destroyers, there was a prohibition against giving away government property. So the legal problem was to create a basis for some sort of an exchange. And somebody, presumably Mr. Jackson, decided that we would exchange these destroyers, which were not in active use by the United States, for bases in the Caribbean, which the British controlled. And he wrote an opinion that laid the basis for that exchange, and it was a great contribution to British resources during a very difficult period for the British. So I associated Jackson with that at the time. In addition, I had some time to follow Supreme Court opinions, and I could see from the beginning that Jackson was the master craftsman, was really a magnificent writer of opinions, and normally included with an opinion some statement that rang through the ages. So I had not a deep sense of Mr. Justice Jackson's gifts, but some understanding of the contribution he had already made.
Okay. Henry King, what about your view of Robert Jackson before Nuremberg?
Well, I recall the attempt by Roosevelt, the alleged attempt to pack the Supreme Court so that he could control it, and I didn't favor it. I took a dissenting view on the destroyer deal because I was isolationist at that time. I since have recognized the wisdom of transferring those destroyers, but that was my
Too
view.
late to get them back.
Yeah, that was my view at the time, and I think he was a very smart lawyer who accomplished Roosevelt's objectives within our legal framework. Mm-hmm. I saw him as an immensely intelligent person, a person who made the law play magic, and so I had great respect for him, although I disagreed with him on issues.
Okay. And that's as a matter of your own politics at the time?
I looked on the Supreme Court as a sacred American institution that had been created by the founders in a certain way. I thought they had a lot of wisdom in the way they went about it, and I think the majority of the United States Senate agreed with my view.
Mm-hmm. Well, let's move into the Nuremberg phase and the actual work on the prosecution of the Nazis. Bernie, did you go to London, or did you go directly to Nuremberg?
Well, I went directly to neither place.
Okay.
I went directly to the State Department and looked at, with a team, and looked at all of the dispatches from Europe from 1933 to the outbreak of the war in September of '39. And we were looking for evidence, particularly of Germany's aggressive intent, and whatever other evidence we could pick up. We didn't get much in the way of useful evidence, but we got a wonderful example how different people looking at the same basic phenomenon interpret reality so differently. Mm-hmm. And we got a political background for the work at Nuremberg, and I think it was a job that had to be done. And having done that, I went off to London for a bit. I didn't have anything to do with the drafting of the charter and the agreement for the charter. And right after London, I was there maybe a couple of weeks, I went to Nuremberg via Frankfurt.
Now, Whitney, you were there during the summer of 1945
Yes.
for the London phase.
Right.
Tell us about that, what that work was about, and did it involve early contact with Justice Jackson?
Well, it involved contact with his members of his staff, but I didn't have any contact with Justice Jackson. But of course, he was there to work out the charter for the tribunal, and this involved the meetings with the representatives from Russia, France, and Great Britain. One of the issues that Bernie has raised was that the question of aggressive war. It was agreeable to the other negotiating parties that aggressive war be included as a crime, provided that the attack was made in violation of a treaty or an agreement or an assurance, something between the two nations. As a matter of fact, Germany had reached non-aggression pacts with practically every country that it attacked, not the United States. Justice Jackson was very insistent that aggression must be considered an international crime and charged as such in the charter, whether or not it violated an agreement between two nations. The fact of one nation attacking with armed force the integrity of another nation should be a crime. You know, it's an interesting thing. I just happened to pick out of my files by an accident this morning a speech that Justice Jackson made after the conclusion of the trial in Brussels. And he raises this very point. He said, "Today, the common sense of mankind is also the law of nations. At least we have mobilized the forces of the law on the side of peace and against aggression." Now, I think we're talking now about the real Justice Jackson. I think this is the primary issue that Justice Jackson wanted to assert in this trial. He says, "The strength of the law may not always be equal to preventing wars, but at least it will no longer sanctify them. But most of all, we men of the law will no longer be perpetuating an immoral doctrine that all wars are legal. Wars of aggression are now beyond denial illegal, and those who induce, incite, or wage them are criminal. The world has taken a long time to reach the point of making it as much a crime to incite a war as it is to incite a riot, as dangerous to attack the world's peace as it has long been to act against the king's peace."
I guess one measure of the success is that doesn't sound very controversial to hear you say that today.
It doesn't sound controversial today, but of course it was controversial at the time that we were negotiating, that they were negotiating the giving of the destroyers to Great Britain.
Well, the French were quite opposed.
Exactly.
And they were concerned about the ex post facto aspect. That is to say, that we were making law after the fact. The Russians had a distinctive Russian view, aggressive war by the Nazis,
Right.
and only by the Nazis
That's
should be condemned. So the Russians were saying, we are not establishing, we do not want to establish a precedent for the future. And that, of course, was one of the primary objectives of Jackson, and indeed, as Jackson emphasized and the tribunal emphasized, the supreme contribution of the trial was that aggressive war, particularly under modern conditions, was the great crime, and that it wasn't enough to regulate how wars should be conducted. It was necessary to stamp it out at the very beginning by condemning aggression. Of course, that doesn't define the difficult issue of what is aggression, nor does it take care of the problem of enforcement. And it is a situation in which, without power, there can be no justice.
Right. Well, power is a nice connection here. How was Jackson able to win the arm wrestling among the nations during that summer of 1945 about whether this should be the vision of the crime or something more narrow, perhaps only the Russian view for this case only?
Well, one, we had all the defendants that were important. And two, Jackson was a tough bargainer. He was willing to go it alone. And the French ultimately gave ground, and I don't think the Russians wanted to stay home. So,
yeah, you're right about that.
And indeed, one of the problems that arose among the staff was whether Jackson's negotiating stance vis-a-vis the Russians had been too strong. But it carried the day, and I think that Jackson had grasped, really, the basic truth about modern warfare. In one sense, he was saying, the greatest crime against humanity is aggressive war itself. And all the other crimes, violations of the laws of war and crimes against humanity and the rest, flow from war itself.
I wanted to add a comment on what Whitney said on the aggressive war count. There is a Rome statute for an international criminal court, and three of us, led by Whitney, former prosecutors, have got that aggression included in the statute for an international criminal court. Not effective now, but can be effective in the future after aggression is defined, and 7/8 of the treaty signatories approved. But it's a memorial to Jackson that's included in the statute, the Rome statute, for an international criminal court.
I want to sound a note of caution here. I think that Nuremberg grew out of very special times and circumstances. And I think very often there is a tendency to reason from Nuremberg without looking at differences in the circumstances of Nuremberg and the circumstances that confront us at any particular time. The critical difference that I think we have to keep in mind is this. At Nuremberg, the war had been fought, and it was not necessary to make war to do justice. We had the defendants. We had armies in the field looking for evidence. The German people were devastated in spirit. There was no problem of creating martyrs who thought they would get a ticket to paradise if they engaged in mass murder. The people of occupied Europe insisted on a trial. There was no opposition throughout the world. So all of the circumstances were right for that enterprise. Other times raised different problems, and I'm not suggesting how those problems should be resolved now, but I think it's very important to keep in mind the special context of Nuremberg.
One of the, when this issue arose during the negotiations at London, General Nikochenko, who was a representative of the Soviets in bargaining, was very sensitive. As Bernie points out, the circumstances, tend to control our viewpoint. General Nikochenko was concerned about the Soviet aggressions against Finland and so forth. The Soviets, and against Poland itself. So, they were very hesitant indeed to agree that aggression generally should be considered a crime. They said, yeah, we'll agree with aggression when committed by the Axis powers. That's fine, the European Axis. And he held to that position throughout the end. Just as Jackson said, we can't agree to anything like that. If that's the case, well, then we'll just go ahead and try the case ourselves. But the thing is, you see, we had all the defendants. Right. And poor Russia, they had two. That's all. They had Grand Admiral Rader, and
he was not.
Was it Durnan?
No. Fritchie.
Oh,
Yeah.
right.
So they had those two, and you know,
Christie
you couldn't have much of a trial with that. So they went along, but of course Jackson absolutely insisted on this issue. This was the big issue, and this is the issue which is going to live in history, I think. Bernie is right. Circumstances affect conditions, but we must accept the view that waging aggressive war is a crime, and I don't think there's any doubt that the world now agrees to that.
I think the important thing is that in the decisions, there was no generic definition of aggression in the judgment of the tribunal. Although the
We
Russians...
didn't have to. It was
No,
so obvious, it was
right,
so
but-
clear.
That's your point.
But
Yeah.
there's not generic language on a definition of aggression.
what's
They
the-
found what the Russians did was aggression.
I'd like to make one more
I mean,
point.
what the Nazis did.
Nazis, it
I'm
was
sorry.
clearly aggression.
Sorry.
I want to make
One
one
more
more point about the Russians, because it underscores that usually in these circumstances, we don't have perfect options. Here, the great contribution of Nuremberg was to outlaw aggressive war and to hold the major architects and executors personally accountable. And who was sitting on the tribunal?
The Russians.
The Russians, who themselves had been guilty of aggression against Poland and Finland and the Baltic states. Nonetheless, in the hopes, I think, of post-war collaboration, we accepted that arrangement and recognized that life is hard. You must make difficult choices.
Well, the problem was that they had played a major role in
Oh, of
the
course,
victory.
Right,
Of
they paid a
course.
terrible price.
Right.
Hey, exactly.
Right.
Right. Let's talk about the trial work itself. You were members of a large staff. Jackson's at the pyramid of a sizable organization. How was it set up? What pieces and roles did each of you play, and how did the work generally flow from and to Jackson in your experiences? Whitney?
Well, of course, Jackson had, at the outset, Robert Story as executive trial counsel. And various aspects of the case were assigned by Story, I presume, in consultation with Jackson, I don't know, to develop. We had decided pretty much at the outset that this was going to be a documentary case. That was the final decision that Justice Jackson made. So therefore, various teams were set up of lawyers. Well, as it happened in my own case, since I had been identified as from OSS, and OSS, under the German system, combined the repressive agencies with the intelligence agencies, Bob Story said to me, well, you go ahead and do what you can, prepare a brief on the Gestapo and the SD. These were the two primary state repressive agencies, and their chief, Ernst Kaltenberg, that was one of the defendants. And they gave me, assigned me an office in the drafty Palace of Justice, a German secretary, a second-hand typewriter, and he said, just go ahead and prepare a brief and get the proofs assembled to take care of this. This is a one-man operation. And so I proceeded. Now, in other cases, there were teams of lawyers where there's a big problem with the economic case or something like that where they needed to get lots of information. And so I had a very pleasant and delightful time in presenting this evidence, and I succeeded in doing so that I was the first one to present a case in court. It was a case against Ernst Kaltenberg.
Right. Now that work, you work in the documents, you write a brief, you assemble the proof.
Right.
How does it move its way up to a supervisor? How does it become known to Jackson? How does it become part of the courtroom proceeding?
Well, we wrote the briefs, at least in my case, I guess you did too. We wrote the briefs, and they were all reproduced, and the tribunal, then the briefs were, of course, submitted for review by the executive trial counsel, in this case, Bob Story, and I don't know others in other cases, and for all I know, Justice Jackson. I really don't know. And in my case, the brief and the evidence was accepted, and the tribunal demanded that the entire we read from the document, any document that we were going to introduce in evidence had to be read in completion, that portion upon which we relied. We couldn't just simply introduce a document, which made it rather tedious and difficult for us. But when the time came for the court appearance, and I was asked to do that, and I presented the case. That's all.
Now, Bernie, you were working in a different part of the project.
I was working initially on the economics case. I reported to Frank Shea, who reported to Jackson.
Okay. And what was the economics case? What's
well,
that part?
The economics case covered the financing of the war, slave labor, the spoiling of the continent, pillaging, plunder throughout the whole continent. Well, now, well before the trial started, Frank Shea left. There had been some falling out, unhappily, between Shea and the justice. And Frank Shea left without a word. And there was no word from anybody else. And so I was coordinating a group dealing with the economic case, and we just went about our business. And then somebody said, well, you will present the case against Funk. Or maybe they said, will you present the case against Funk? And initially, against Schock. And I said, yes, sir. And I made an independent study of the Schock evidence, and I concluded he would be acquitted. And I was getting mail from the States, from the lefty press, saying Schock is going to be acquitted because he's a banker and he knows all the other bankers, and the bankers will look after their own. Well, I guess I was then the youngest person on the prosecution staff that had a speaking part. So I thought it was, I should report to my bosses that they could be criticized for sending a boy to do a man's job if Schock was acquitted, as I thought he would be. I made it quite clear it was quite sensible for me to deal with Schock and Funk, because Funk had succeeded Schock. Well, there was a silence. I was relieved of the Schock case, and then to my astonishment, Grady Bryson, who was either 2 weeks younger or 2 weeks older than I forget which, he was asked to do the Schock case. He did a brilliant job, but Schock was acquitted. Now, the other thing that came to me had nothing to do with the economic case. I was still working on the Funk case when, I guess, Tom Dodd was then executive, what was he?
Trial counsel.
Trial counsel, but he was first lieutenant.
He was a
Deputy. So he said, there's a mess in the concentration camp case. There were 10 days to go. You needed 3 days for production. Would I sort of finish it? I said, if I get 2 German-speaking lawyers whom I identified, I'd be glad to do it. And they came on board. They dug into the evidence, and they scrounged for evidence. I wrote as fast as I could, and we got it done in 7 days. But one of the extraordinary reactions we had was, here's the concentration camp case, the emblem of the Nazi regime. Right. And the supervision of that case was so loose that nobody, until 10 days before, knew that rescue efforts were necessary.
Right.
But there was such, what should I say, richness is not a word except to a lawyer. There was such a mass
With a lot of
evidence.
Right.
Oh,
Right.
and the German tendency to keep records
Right.
really made all the difference. in the
Right.
world.
Right. Now, Henry, you arrived later. The trial was underway.
Yeah.
Where were you plugged in to the
I
trial?
was plugged into
work?
the German General Staff and High Command case. They were tried as a group at Nuremberg, and I worked under Telford Taylor. And I worked on the case itself. I worked on the brief against the General Staff, also on Jackson's closing statement regarding the German General Staff. Also, I was assigned 3 defendants who were members of the German General Staff. One was Walter von Brauchitsch, who was Commander-in-Chief of the German Army. Another was Heinz Guderian, who was Chief of Staff of the High Command of the German Army. And the other was Erhard Milch, who was head
Now,
of
they
Luftwaffe.
weren't defendants in the initial international trial.
Well, they were part of the group.
They were part of the High
They were not
Command.
isolated as defendants
Right.
in the first case,
Okay.
but they were part of the group which were included in the General Staff case. Later in the decision, the General Staff was not found to be a cohesive group, and so we pursued cases against them individually.
In the later trial.
Later.
That's right, yeah, and I prepared the case against Brauchitsch, and he was turned over to the British. Case against Guderian, Guderian was about to be turned to Poles, and we got in a fight with the Poles over the Oder-Nissel line and the boundaries there, and Guderian got as far as Berlin, and then came back and was freed and went to North Germany, where my recollection is he engaged in some neo-Nazi activities. But Erhard Milch was the case I was the driving force on, and we tried it at Nuremberg, and I was assigned the underground aircraft factories phase of the case and tried in part that. At the same time, Milch was given a life sentence for slave labor. He appealed to the Supreme Court, and the Supreme Court on a 4-4 decision refused to take jurisdiction.
The Supreme Court of the United States.
Supreme Court of the United States. Yeah,
With
right.
Robert Jackson not participating.
Not participating,
Right.
yeah.
Right.
So
That made
I was,
the stone that you were around happy.
yeah,
Right. He was gone, but I'm sure his ghost was happy.
yeah.
Right.
I also played a miscellaneous role on as a utility fielder on cases like the Ministries case and the case against the lawyers.
Well, one of the outset, the concept was that individuals would be brought to trial. There were 24 originally indicted, of course. But then the view was that we must reach farther than this. This is the major trial, and therefore we'll indict organizations and have them declared criminal by the tribunal. Then in a subsequent proceeding, where individuals are brought to trial before perhaps a German tribunal, that fact will be already established, that the organization of which they were members was a criminal organization. Now, the tribunal was very concerned about this and what the consequence might be, so the tribunal very rightly conditioned this ruling upon a finding that the person joined voluntarily with knowledge of the criminal objectives of the organization. Nevertheless, this was utilized in subsequent trials by German tribunals under Control Law Council 10, and individuals who came before the German tribunals and were members of the SS, say, if established that they did join with knowledge of the criminal purposes of that organization, were then punished by the German tribunal.
But the concept I think the concept of holding associations criminal and making membership without regard to knowledge
Right.
criminal was really not a good idea. And it
No,
created
everybody.
it created great problems in the courtroom because the lawyers were really challenged by the tribunal on that,
Yeah,
and
well-
the tribunal fixed up the charge.
Judge Parker was very strong on that.
Well, one point.
And he was right.
Is
He was
that
right.
The general staff was right as a group. They were not convicted, and then the individuals
Right,
were
yeah.
charged.
Well, there were only 4 organizations that were convicted. The leadership roles of the
Right.
party,
Gestapo.
the Gestapo, the SD, and the SS. I had 2 of them. I had the Gestapo. and
Let's
the-
turn to direct tasks for Jackson. Were there things that were specific requests or assignments for him that fell to any of you? Bernie? No.
No. There was a problem of volunteering. Because I was interested in Funk and Schock, I interrogated Goering pre-trial and picked up some items that might have been helpful to anybody getting ready to cross-examine him.
Or to make the opening statement?
Well, this was well after the opening statement.
Of course, Goering and Schock were not exactly friends.
Right, exactly. And the argument, indeed, it was said that Schock resigned, not out of principle, but because he lost the power struggle with Goering. In any event, that is why I was interested in Mr. Goering. And what I had was not of central importance, and it wasn't that the military tradition, don't volunteer, was dominant, but I decided, oh no, the justice has a lot on his plate.
Right.
If anybody wants what we have, we will be asked.
Right.
But so far as I was concerned, none of my work in the way of assignments came directly from the justice, and I got no supervision from him. And in fact, so far as my brief in support of the prosecution case for Funk was concerned, no one looked at it besides me. And so far as the concentration camp case, there was not a single word changed. So I'm quite sure that Mr. Justice Jackson did not see those papers.
Right. That case ultimately was not presented by Jackson.
No, that was
it?
by Christoph.
That was Tom Dodd.
Tom Dodd, sorry.
Right. Now, Whitney, I think you had an experience that was a little bit different. What kinds of things did Jackson need that fell to you? What kinds of project contact did you have with Jackson?
Well, aside from my basic case, of course, which is against Kaltenbrunner and the Gestapo and the SD, as far as I know, I had no direct contact with Justice Jackson at all in the preparation of my briefs, or even the presentation in court, or the cross-examination of witnesses. I cross-examined a few witnesses. As far as I know, now I did have a very significant role, however, with Justice Jackson, which was in the cross-examination of Furman Goering.
Right. Tell us about
And
that.
well, that was really a climactic time of the trial. Normally, Justice Jackson would have with him at the desk beside the podium L.C. Douglas, his secretary, or Bill Jackson, his son, who would help by handling the documents that he might need in the discussion presentation. The cross-examination, in the case of the cross-examination of Herman Goering, he asked me to help him. This was a very critical time of the trial. It was a very important trial. The trial, everything had been rather dull for some time. The press was all alert to the excitement of the chief prosecutor for the United States cross-examining the leader, really the chief leader of the Nazi regime, now living.
Right. Symbolically, he was the biggest defendant.
And he was on
And the fattest.
He was unrepentant,
Right.
you see. And all his business about the laws of war, obsolete. So he attacked the fundamental basis of the trial.
Well, let me explain what actually happened, since it was my responsibility. Now, I want to say at the outset that Justice Jackson did himself developed the line of examination, cross-examination from Goering. That wasn't my function. That was Justice Jackson's function. His concept was, we can prove through this witness, because he is so arrogant anyway, that the whole concept of the Nazi conspiracy, the seizure of power, the preparation for the assault on other nations, the following through with the destruction of populations, the extermination of peoples, and so forth. We can prove this through this witness. Now remember that when Jackson persuaded the British to a trial, rather than to eliminate these people through executive action, the British concern was, we shouldn't afford these individuals an opportunity to espouse Nazism from the courtroom. You give these fellows a trial, they'll get on the stand and they'll talk all about Nazism and get the German people all upset again. Better to get rid of them with executive action. That was the British contention. That was the concern of the British. This was the concern of all of us at the outset. At that point, Jackson was, Goering was the first defense witness. This was going to be a truly dramatic thing. And Goering was an arrogant person. We all knew that. Jackson sought to prove the entire conspiracy through this witness. He started out by saying that as soon as you got into power, you were determined to eliminate the Weimar Constitution. You were determined to make a dictatorship, eliminate the right of people to vote, and so forth. That was his concept, to show how these Nazi conspirators seized power of Germany, controlled power of Germany, supplanted the will of the people, and then engaged in aggression, and in connection with aggression, with his terrible crimes against humanity. The concept was perfect. So we started out, and Goering was very good. But Goering soon got the idea that, well, he could expand a little bit on his responses. And he would say, I don't know what you do in the United States, you do the same thing. Or words to this effect. And every question that Jackson would put to Goering, Goering would come up with some smart answer. So Jackson was extremely concerned about this, and he then made his challenge to the tribunal and asked Lord Lawrence to control, instruct Goering to control himself and not to make these expansive answers, which were not really relevant for the most part. But Judge Lawrence was, apprehensive, again, of the fairness of this trial. This was so important. We must not show any indication that this is a tribunal set out to convict. And so Lord Lawrence gave Goering much more leeway than a judge would give a witness in a court in the United States of America. And this got Justice Jackson very upset. And that is what led to the altercation that happened 2 or 3 times in the the complaint to the tribunal. However, all this disappeared after we got by this, when we got into the sordid role of Goering in the mistreatment of the Jews and mistreatment of captured Allied airmen and so forth. And toward the end of the examination, when the press really was not too much interested anymore, Goering just hung his head and answered the questions and didn't attempt to make any long-winded explanation of anything.
The early questions were more open-ended.
Yes,
The answers were open-ended.
well, I warned
that,
Justice Jackson.
and the strategy involved that risk.
Right.
But Jackson...
You were there watching.
Oh, I sure was.
Okay.
I was watching, and it was not the happiest day of the trial.
Right.
But Jackson, having laid that general basis, created the groundwork for the British prosecutor to ask very tight questions.
Yeah, that's right.
And the combination of the two cross-examinations, which I think is a fair way to look at it, really did a job.
In the end, we destroyed Goering. You're quite right. Sir David Maxwell Fyfe
Sir
did,
David Maxwell Fyfe.
but he was alert from the outset that the danger of this approach.
Yes,
It was a
that's right.
dangerous approach.
was.
And
Whitney, you started to say
Yeah.
you had warned Justice Jackson.
What?
You had warned Justice
No,
Jackson?
I had not warned Justice Jackson. No. I went right along with the concept, but I was a little concerned about it. But no. Who am I to do that? No, I wouldn't do that.
But I don't know if this is a fair question, but I will ask it. And that is whether, because Justice Jackson had been a Supreme Court justice and had been accustomed to great deference, whether the arrogance of Goering got to him.
Well, yes, I think that's absolutely right, and Goering was arrogant,
Oh,
and his responses were his answers were not responsive in some cases. He did go beyond, I think, the realm of proper response to questions, even on cross-examination. Jackson's position was, he said, well, you can on redirect. You can say anything you want. Go ahead on redirect, but I want to proceed here and answer the question, and we don't have to have a long-winded response. But Lord Lawrence, with that British tradition of absolute fairness and all, and thinking of history, and the concept that this trial must be established as the fairest possible trial, I think he leaned over backwards to let Goering. And as a matter of fact, as I look back on this now, Goering himself restrained himself to some extent in his answers after Jackson made his appeal to Lord Lawrence, even though the judge did not require him to restrain. Even Goering realized that he was, answering questions with remarks which were really not relevant. And as I say, toward the end, he just answered the question yes or no. And for the most part, Goering was honest. When we interrogated him on issues relative to the treatment of Jews or the crystal knot, where it was a disgusting behavior on Goering's part, he said, I would not, I'd just like to say, I would not want to be a Jew in Germany today, and things like that, He didn't, he gave up.
Didn't Lord Lawrence's approach add credibility to the trial, the fairness of
Yes,
the trial?
I think ultimately it did.
I think his approach was...
But it lost us, the press. The press, didn't understand what was...
They treated it as an isolated...
Right, but we can look back on it, and it certainly has importance from a historical standpoint.
But from
If you shut him off and didn't allow him a speech, then you could be accused of unfairness.
Well, it's better...
exactly.
Yeah, we gave him enough rope to hang himself.
Henry, you mentioned earlier that you were able to draft some material for Jackson's use in his closing statement. Tell us about that piece of work for the boss.
Yeah, I thought this was my moment in the sun. I thought I was a good writer, and it related to General Staff and High Command. And I worked all night on this thing. I thought I was a good wordsmith, and I looked to my knowledge, my language, to be part of history. But when the closing statement came out, I didn't find a word that was mine. And I later found out that Jackson didn't like ghosts as such. I think he condemned them, didn't he, Bernie, in a Supreme Court decision. I was disappointed, but I took years to find out why I didn't appear in that closing statement through these words. And these words were not immortalized, but the words were his. but my understanding of Jackson in later years grew, and I thoroughly understood it.
Right. He was a man who did his own work.
Absolutely.
Happy to receive good input, but did his own writing.
Right. And the words were immortal, the words he used. They spoke worlds in short sentences, and the Jackson words will live forever, I think. That's right. 1,000 years from now, we'll be remembering pieces of that opening statement. We've never had anybody quite like him.
Let me ask about other observations and opportunities you had during this year at Nuremberg to see Jackson, his courtroom work, his office work, perhaps off the job or social settings. What other memories do you have of Robert Jackson, Whitney?
Well, of course, his courtroom work was just impeccable. He always wore his morning coat, and he conducted himself in an exemplary fashion. Very intelligent in his examination of witnesses. His questions were extremely good. He was perhaps not as aggressive as some might be, but his greatest contribution in this respect was his speeches that he made, his opening address, his closing address. He's a writer, a legal writer without parallel in the 20th century as far as I'm concerned. He was absolutely persuasive, and his language, choice of language was exemplary and beautiful and effective, and he was a strong speaker. He just has to be a giant among lawyers.
I think those speeches ought to be must reading for students of American history. I think that the words are very persuasive, as Whitney says. I think he was able to put in concise form men's ideas and carry them through.
It was not only the ideas, though. It was also the way he summarized the events of an epoch, covering continents, and the sequence, the organization, just added to the power of his language. I mean, the clarity of his understanding was reflected in the flow of the language and the interrelationship of the one paragraph to the next, so that whatever differences one might have about Jackson's cross-examination or any other facet of his trial work, the contribution of those statements make any imperfections seem, as the lawyers say, de minimis. They're just overshadowed by this enormous contribution to the trial and to the understanding of the enterprise and the understanding of the Nazi regime.
Right. What about outside of the courtroom? What was he like in the other settings that were part of the Nuremberg experience?
Well, I remember two settings. For reasons unknown to me, I was invited by the justice to be part of a group that he was hosting in Garmisch. And I remember Jim Rowe.
Garmisch is in the Alps.
In the Alps, right close to Hitler's, what was this, his Eagle's Nest?
Eagle's
Well,
Nest.
you're talking about, you're not talking about Garmisch, you're talking about Berchtesgaden.
Berchtesgaden, I'm sorry, you're
We
right.
were there at this time.
We were there. Well, anyhow, I
It was over
remember
Christmas.
going to Berchtesgaden and having that magnificent view and wondering, what more could Hitler want? What kind of maniac was there here? And then I went down to the R&R retreat, where recreation, rest and recreation, where there was lunch. And I had a somewhat embarrassing experience. I played a couple of sets of ping pong, and I think I had a highball and sat down to lunch. My luncheon companion was the wife of the French judge, there was not, what should I say, strictness about separation of powers there. And in the middle of lunch, I excused myself, and when I woke up, I was prone, and somebody was working on me, and he said not to worry, 20% of the people who come there and don't wait to adjust to the altitude pass out. But I said to him, I'm afraid Mr. Justice Jackson will think it was the alcohol, not the altitude. So he served as my lawyer, and the justice was very understanding. And I remember another larger group when Mrs. Biddle came over, and the Biddles had an international party, and Mrs. Biddle decided to teach the Russians the Virginia reel. And I saw how amused the justice was at that exercise. But I didn't have, quite unlike Dean Atchison or Jerome Frank, I didn't have many face-to-face meetings or any sense of personal friendship with the justice. He was a commanding figure, dignified, powerful, and enormously able, but not somebody I worked with day by day.
Right. Well, these moments do start to give us a glimpse of the personality. Whitney, how would you describe Jackson in terms of temperament and attitude and style, you know, as a man, as a person?
Oh, Justice Jackson was a man of very strong and positive convictions. If he believed in an issue, he would stand for that issue through everything. This is demonstrated by the negotiations in London, for example. Justice Jackson would not give 1 inch to the other participants in the trial if in respect to the manner in which this trial was to be conducted. It had to be a trial which would be acceptable in the eyes of lawyers in the United States and in our own system of justice. He was so determined that he would have given up the trial, absolutely, and therefore he persuaded them to, on all American points, he prevailed. So he was a man of great determination. He was a man of kindness to people like us who were low down in the prosecution staff, you might say. He was a friend. He was kind. He, of course, sometimes he asked us for help, and we were able to give it to him. But he always was considerate of the person down low in the totem pole. He wasn't afraid of challenging those that were higher up, as, for example, in the case of General Donovan. I mean, General Donovan had a very good point that we should start out this trial with some of the leading German leaders of Nazi Germany and really expose the type of people they are through cross-examination. Justice Jackson, thinking about the status of the trial in history, rejected this report. It didn't matter that General Donovan was a very powerful man and had been selected by him as his #2 man. General Donovan went home. So he was a man of his own convictions. Now, he did have a tendency, I think, perhaps to, could be irritated. As we talked about the cross-examination of Goering, he was irritated. He did lose his temper, you might say, to some degree. If that's a fault, that's certainly the least fault that any great man could have.
I think he had the courage of his convictions in the face of the slings and arrows of his countrymen. After all, Chief Justice Stone disparaged the Nuremberg trial as a high-class lynching expedition. Took a lot of criticism from Taft, particularly in a Kenyon College speech in 1946. but Jackson stuck with it. That's the important thing. And he thought he was right, and he had strength to see Nuremberg through and never to lose the vision that he had of a better world through Nuremberg.
With respect to convictions, there's a kind of parallelism between Taft and Jackson.
Yeah.
Taft got a lot of criticism for his criticisms of the
Jackson,
trial
right.
and of Jackson, and then Taft made it in Kennedy's
Profiles in
Courage.
That's right.
And of course, it used to be said of Senator Taft, he had the best mind in Washington until he made it up. He stuck with it.
Now, let's talk to the bottom line. You've described the skills and temperament and ability of this extraordinary lawyer. And from each of your perspectives as a participant, Nuremberg was about something truly important. For the general public and today in 2001, what did Nuremberg accomplish? Whitney, how do you see that?
Well, I think Nuremberg has set a completely new standard of international law with respect to the responsibilities of the leaders of nations. No longer can any person who is responsible for the affairs of a nation, who leads that nation into aggressive war, for example, say, well, after all, this is the act of the country and not my responsibility. Nuremberg, and this is without a doubt Justice Jackson's greatest contribution, is that leaders of nations who lead their country into wars of aggression have got to answer personally for the crimes committed in that engagement. This is Jackson's greatest contribution, I think, to international law. He also, I think, has set a standard that no individual shall be punished for a crime, alleged crime, in international law, unless he has an opportunity to defend himself, a fair chance, a judicial proceeding. He has brought the concept of the common law into international law, really. And we now live, if we follow Jackson's precedent, his thinking, we live in a world in which leaders of states that engage in aggressive war are personally accountable for the crimes committed in the course of that aggression. And this is his, I think, his greatest achievement.
Okay. Bernie, how would you answer?
I would agree completely with Whitney's giving paramount importance to aggressive war and personal accountability. In addition, I think this theme has been sounded before, but it bears repetition. I think creating this history of the Nazi regime was a justification for the damage that we inflicted on the German people, and was also a reminder to them of the consequences of their silence about the regime that was responsible for the war and the atrocities that preceded and surrounded it. I think that, in addition, the facts about crimes against humanity, as distinguished from the concept as dealt with in the tribunal's judgment, the facts about crimes against humanity really stimulated the whole growth of humanitarian law. We have there, of course, great aspirations. We have problems of enforcement, but nonetheless, the aspirations in many quarters will affect conduct, and in others, if conduct is not effective, and we have power to capture those guilty, we will have a precedent for dealing with them in a way that's just and fair and gives them an opportunity to defend themselves.
I think that Jackson introduced the concept that international law applied to individuals, that individuals had rights and duties that were international in scope. Milosevic is on the dock at The Hague today because of the introduction of responsibility of higher-ups. So Jackson symbolizes human accountability for mistakes and for crimes. Also, I can say with some conviction that Nuremberg marked the start of the international human rights movement. It was the first implementation in the court of international human rights. Also, in the judgment in the statute that Jackson, the charter, London Charter of August 8, 1945, the fact that the Nazi laws approved of what was done to the Jewish people was not held to be an excuse. That's in the statute, our Charter of London, that you can't hide behind national laws. So I think Jackson was important in limiting sovereignty as a means of hiding behind the nation state for crimes that had been committed. So it's a whole new era of international law. It's had immense influence on our world today. We're not finished with it, but I think the International Criminal Law Court, which is designed by the Rome Statute of 1998, is a step forward on institutionalizing what Jackson's concepts were on a permanent basis, not just an ad hoc basis.
Well, gentlemen, that's a wonderful catalog of the achievements of Robert Jackson and the work at Nuremberg. I would close by reading just a short excerpt from an interview he gave to a historian in 1953, the year before he became ill and then passed away. Jackson said, "As to my personal feelings about the trials, I regard it without qualification as the most satisfying and gratifying experience of my life. The success in carrying it through being the only joint effort between Americans and Soviet that has succeeded since the war, I look upon with a good deal of satisfaction. Notwithstanding the imperfections of the agreement in London, I think it represents a very important contribution to international law, and the trials represent an important contribution to legal history. Despite all the wear and tear and personal inconvenience of the trials, I'm sure that given a similar opportunity, I would do it again."
Well, you know,
Is that a view
That's
that you
wonderful.
share?
Well, if Bernie and Henry were there, I'd go to.
Gentlemen, on behalf of the Robert Jackson Center,
Okay.
thank you to each of you for participating.
All right. Well, it was fun to be here. It's a delight.
On behalf of the Robert H. Jackson Center in Jamestown, New York, I'd like to thank the participants in this discussion, Mr. Whitney Harris, Professor Bernard Meltzer, and Professor Henry King. These are men who were on the staff and worked with Justice Robert Jackson in the prosecution of the lead Nazi war criminals, Nuremberg, Germany, 1945, 1946. Thank you very much for sharing your memories of that time, that work, and that man.